Yeah. Members, we're going to move forward. Senator Davis has the floor.
Thank you, Mr. President. Now, I'm going through this bill analysis bit by bit because I have something to say about all of it, and I want to make sure that the public understands exactly what the provisions of this bill require. We were just having a conversation about post-fertilization age, and that the physician is required under the terms of this bill to determine post-fertilization age, and the physician can then only perform or induce or attempt to perform or induce an abortion once he or she has determined that the fetus is 20 weeks or less from fertilization. And I want to make a point about the incalculability of that and what we are subjecting doctors to. And if we say to doctors from this point forward that that's the starting point, how in the world are they ever going to make that determination? And to be on the safe side, let's face it, the way they're going to make the determination is they're going to overcorrect. And it's very likely that in the overcorrect, women who are 18 weeks gestational age of their fetus, those women will have a very hard time finding a doctor who doesn't want to risk violating this because the doctor can't be clear about the $20 million question of when fertilization occurs. Now, a doctor can rely, it's kind of interesting under the bill, they can rely on the determination of that post-fertilization that another doctor has done. And so now we're going to have two of them involved. So now we're going to ask, and I just don't see that this will ever occur, that one doctor is willing to say to another doctor, you know what, fertilization occurred on November the 8th. And therefore, 20 weeks from November the 8th is X. That's physician A. And then physician B says, well, I was relying on what physician A told me. So now we got two of them who potentially have a problem. What if physician A says, I didn't say that. I was talking about the date of the last menstrual cycle. I was talking about the date of the woman's last period. I wasn't talking about fertilization. How am I supposed to know when fertilization occurs? And what we know, members, by doing this is we are subjecting doctors to a requirement that they cannot meet. And we're asking them to put their practices essentially on the line if they make a mistake. So in the grand scheme of what we've been talking about here and the impact on women in Texas, there's so many people who say, this isn't going to limit women's ability to have abortions in the state of Texas. Well, yes, it is. Because every single one of the pieces of this legislation that I've been talking about adds up to a sum, and that sum is one that creates a greater and greater and greater challenge to women in the state of Texas to do what? To exercise her constitutional protected right to have an abortion, to exercise the most difficult decision of her life. And members, we've all heard from these witnesses. I read from so many of them today. You heard their testimony in committee. We've heard them before. We heard them when we were taking up the sonogram bill last session. And we know that women can find themselves in situations where the provisions of this bill are going to create true hardships for them. And you heard it in some of the letters, a lot of women really resent the fact that this legislating is being done and voted on, look around the room, primarily by men. And yes, there were a few women over in the Senate side and a few over in the House side that supported this bill. But you can imagine, or maybe you can't, how a woman feels to be told that her feelings on these issues, that no matter how difficult, no matter the circumstance that she's dealing with, if she can't fit into every one of these little square pegs that she's going to be asked to be fit into by this bill, she is not going to be able to exercise her constitutional right. And what's so disturbing is that we don't seem to care. And maybe that is because so many of us on this floor have never ever had to face that and never will face it because you don't have the equipment. And I've got it. And my daughters have it. And other women that I care about have it. And women who I don't know have it. And what I know for a fact is that each of them has a unique circumstance that's going to be impacted directly by virtue of the provisions in this particular bill.
Mr. President.
Senator Jewell, for what purpose do you ask?
Ask Senator Davis some questions. Would she yield?
Senator Davis, do you yield?
I'm not yielding for any questions at this point.
Senator
Thank
Jewell,
you,
Senator
Mr.
does not yield. Senator Nelson, for what purpose?
Well, I was going to ask if the gentlelady would yield.
I don't wish to yield for a question at this time.
Mr. President, may I ask the gentlelady if there is any point this evening that she will yield for some questions from another woman?
I may do that, but I am not yielding for a question at this time.
Thank you, Mr. President.
The floor is yours, Senator Davis.
Thank you, Mr. President. Now, the prohibition in this bill says that a doctor can't perform or induce or attempt to perform or induce an abortion on a woman if it's determined, as we said a moment ago, that the fetus is 20 or more weeks post-fertilization. We've already talked about how difficult that is. But then there's a provision in here about the method of abortion. And again, this implies or puts in place a requirement that physicians function from a post-fertilization age perspective when applying the provisions of this particular piece of the bill. But it does say that there are exceptions. And it provides that the prohibitions and the requirements under the bill and all the sections thus far that I've referred to do not apply if there exists a condition that in the physician's reasonable medical judgment would so complicate the medical condition of the woman to avert the woman's death or a serious risk of substantial and irreversible physical impairment of a major bodily function. And we've talked about that. So now there's an exception to this 20-week bill. There's an exception. And the exception puts a doctor once again in a very precarious situation because it provides that the doctor, number one, using reasonable medical judgment. So we're in the trial, and I can just tell you how that goes. First thing that happens is the jury or the judge is going to have to decide what was reasonable medical judgment. And what's interesting about that is oftentimes you have a lot of people who don't really know what reasonable medical judgment is. You, of course, call experts to the stand and they talk about what might be reasonable and what wasn't reasonable, and juries have to put themselves in the mind of a medical professional, and they have to decide what is reasonable medical judgment. But then they've also got to decide, was that judgment reasonable in relation to other terms that are fairly subjective in nature and require, and I think differing minds would agree, when these conditions are met. The conditions are this: that in the physician's reasonable medical judgment, failing to provide this service, this post-20-week abortion, would so complicate the medical condition of a woman that to avert her death or a serious risk of substantial and irreversible physical impairment of a major bodily function must be demonstrated. Now, I wonder what that means. Irreversible physical impairment of a major bodily function. I've been pregnant. I'm sure a lot of women here and in the gallery have been pregnant. And we've probably had changes in our bodies that have occurred as a consequence of that. Some of us might refer to them as physical impairments. For many women, I hate to be graphic, but for many women who have carried a child, she has problems holding her bladder. She has problems with urination. I wonder if a jury would think about that as being a physical impairment. I wonder what a jury might decide was a irreversible physical impairment that justified a doctor using reasonable medical judgment to avert. What might that be? And there's no guidance. There's no guidance in the bill analysis. There's no guidance in the bill itself as to what that might be. And does it make you pause for a moment and consider why the medical community has so many concerns about this bill? What are they subjecting themselves to? And will doctors continue to practice in this arena? You know, we talked a lot about that before I was here, but it was a major part of the conversation in deciding whether we should move forward with tort reform. Part of the argument being that when doctors feel like they're subjected to unreasonable risks, they will not practice in that arena. On the tort reform arena, the arena was the state of Texas. And there was argument made and information put forward that doctors were leaving the state of Texas, or if they'd gone to residency school somewhere, they weren't coming back to the state of Texas because they worried that they couldn't practice here without subjecting themselves to unreasonable risk. Could that perhaps be the purpose of legislation like this? Could perhaps a justification, a motive for legislation like this be in any way related to having physicians think twice about practicing in this area of medicine? Could it be that in Texas what the hoped for outcome would be that fewer and fewer doctors practice in this area of medicine? And as a doctor, I wonder what they think about that particular piece of this. And as things advance, I wonder how many will be willing to take these risks. Now, there's also a provision here that protects privacy in court proceedings. And it's a good protection, I think. It's assuring that in the laundry list of litigation that I've just gone through in the last hour, that when that litigation occurs, whether it's in a criminal court of law or a civil court of law, the woman would have her identity protected and not subject to public disclosure if she does not consent to giving that disclosure. And there's a greater protection here, requiring the court to issue orders to the parties that this protection would be in place, to witnesses and to the counsel, that they aren't to reveal outside the courtroom a woman's identity who may be a subject of a proceeding where a doctor is actually having some challenges to provision of the medical care that they provided. And then there is some provision that would authorize a court to disclose that information in certain circumstances. Number one, if a motion is filed with the court requesting it, if notice of that motion is served on each interested party, and if the court determines that disclosure is essential to the administration of justice and there is no reasonable alternative to disclosure. Now, what does that mean? When might a court find that disclosing the identity of a woman who's had a very traumatic procedure and who's gone through the personal pain and the scarring of having undergone that procedure, when might it be the case that that woman, her identity, would be disclosed because it would be deemed essential to the administration of justice and that there's no reasonable alternative to that disclosure? Might that have a chilling effect? Could that be the hoped-for impact?